Well, hello, friends. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, principal and founder of Carolyn Lee PLLC, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. And this is a momentous occasion because I am introducing our senior attorney, Lindsay Schoonmaker, to you all today. And we're going to do a proper introduction and say a little bit about her background. And I'll just say that I am beyond delighted and honored and ever so happy to have Lindsay join us. So today we're going to be talking about the unreserved visas in the EB-5 category. And there's been some important news items circulating in the EB-5 community about the unreserved visas. So I thought, you know what, this is a fantastic time to introduce Lindsay and to talk about the unreserves and the whole kind of system of visa numbers, particularly in EB-5, particularly in our post-RIA landscape. And the unreserved is really such an interesting area to talk about because it is really where the pre-RIA investors meet the post-RIA world set up by the EB-5 Reform and Integrity Act. So let's just kind of kick it off and get going. What do you say, Lindsay?
That sounds fantastic. I'm so excited to be here for this first webinar.
Yay, yay. Okay, let's do this. All right, how's that looking?
There we are.
Awesome, there we are. Okay, so let's start with a disclaimer because we are attorneys. This presentation is informational only. No part of this presentation is legal advice. No attorney-client relationship is created without a signed engagement agreement between Carolyn Lee PLLC and client. The content may be promotional and should be considered attorney advertising. Any timeframes are estimates and will vary widely, and the contents are copyrighted. Okay, so about the firm and about myself. And whenever I do this, I've got to say, okay, I'm doing this for the team. A little bit by way of introduction. So super honored to have enjoyed 18 years, I think it's almost 20 now, of EB-5 leadership in the bar and industry, a 6-term chair, co-chair, and vice chair of the American Immigration Lawyers National EB-5 Committee. We've done some incredible work through that committee. Legislative counsel to invest in the USA. Amazing experience and super big honor to have been on that dream team that led to the passage of the EB-5 Reform and Integrity Act of 2022, working closely with staff members of Senator Grassley and Leahy's office. Thank you again to those offices. Co-chair of IIUSA's Public Policy Committee, where we are really keeping our ear to the ground about how the agencies are interpreting the RIA, the effects as we see them on the ground in adjudications, and advocating for the best interpretation of the RIA. In terms of professional experience, I have represented project clients who have successfully raised over $2.5 billion in EB-5 capital alone, stacked with other capital and projects all across America. Incredible projects spanning manufacturing, alternative energies, traditional energies, and of course, real estate. And thousands of investors represented across these almost 2 decades from the start of their EB-5 journey all the way to the end of their 829 approvals, which is a glorious time that we all celebrate. And about Lindsay Schoonmaker. Lindsay, do you want to walk us through how you got here?
Sure, absolutely. So my most recent experience is that I was a supervising attorney at an organization in Philadelphia called Philadelphia VIP. which is a pro bono organization that helps match low-income Philadelphians with volunteer attorneys from throughout the area to work on a whole variety of issues, general civil legal issues, from name changes to home ownership to small business and nonprofit issues, a really wide range of civil legal issues. Before that, I was an associate at a Philadelphia-based law firm, which at the time was called Pepper Hamilton. I was in a commercial litigation practice group and did a lot of my work on complex commercial litigation, contractual issues, antitrust, and international arbitrations. I went to Temple Law School, and I went to Cornell for my undergrad education. And when I graduated from Cornell, I worked as a legal researcher writer at an immigration law firm where Carolyn was my mentor and taught me so much. I worked on a wide variety of immigration cases there, mostly employment-based, but touched a little bit of everything and got to learn about EB-5 that way. And I'm really excited to be working with Carolyn again, learning from Carolyn again. I'm very excited to be here.
Welcome, Lindsay. There just aren't really, words are inadequate to describe my feelings and welcoming your return. So welcome, welcome, and thank you for being here today.
It goes both ways.
All right, folks, let's jump into this. Okay, so you know me, a little geeky. I want to get into talking about what are we really talking about? So let's do that by spending a little bit of time on the foundations of the visa system in EB-5, and then we'll get to how this all ties into unreserved visa category in the EB-5 space. So the foundational framework is, of course, the Immigration Nationality Act, or the INA, and it sets limits. These are a capped number of visas that may be allocated worldwide on an annual basis. We are in Section 201D of the INA, which sets the worldwide limit for employment-based immigrants, and EB-5 is an employment-based immigrant visa category. There are 140,000 visas allocated to employment-based visas annually. And we in EB-5 get 7.1% of that annual allocation of 140,000, which pens out to about 9,940 annually, normally in all of EB-5. What's also relevant for our understanding here is the per country cap, which we will devote another webinar to entirely to talk about. Section 202A2 sets the per country limit at 7% of the worldwide limit of 140,000 to nationals or natives of any single state. That number is in EB-5 is going to come out to about a little under 700 annually. So you take 7.1% of the annual limit, which pens out to about 9,940. You take 7% of that, and it's usually about 700. Why are visas exceeding that number given annually to the high demand countries, investors like from China and India? It's because we have that cap at 7%, but not all of the other countries, in fact, none of the other countries reach their 7% per country cap. And so those unused numbers from the other countries get carried over horizontally, if you will, to the high demand countries. So the high demand countries benefit from the underutilization or the relatively low demand from the rest of the world countries. So Section 203B5 is where EB-5 lives. We are Section 203B5. And this is where the allocation of the 140,000 happens to the EB-5 category. And that 7% of the 140,000 is split this way. So we're at 7.1% of the worldwide level. That's the 9,940 approximately. But of that annual limit, we have reserves, or what we also call set-asides. Now, we have 32% of that annual limit that is set aside in these three subcategories or set-asides. We have 20% of the 32% going to rural projects that are cited in rural areas, 10% going into projects cited in high unemployment areas, and 2% in this new category of infrastructure. Now, the RIA has a mechanism that's new. This is new in the INA, where unused visa numbers in the set-aside categories will carry over the next year to the same category. So if there were, let's say, only 10% used in rural in 1 year, the remaining 10% will be carried over to rural. It'll stay in rural and be added to the annual 20% allocation of set-asides for rural in that succeeding fiscal year. Now, if the numbers are not used in that same category that year, that succeeding fiscal year, then those set-aside numbers will carry over into the unreserved categories in the second succeeding fiscal year. So let's kind of take a look at how that all works in operation. So I'm going to try to see if I can get this screen moved out of the way. Okay, so here's the normal limit, 140,000 plus unused family-sponsored numbers from the year before. That's how the INA works. EB-5 annual limit, 9,940, that's our 7.1%. The unreserved is the 68%, and that pens out to 6,758. There are some rounding differences. So some folks will round up, others will round down. I tend to round down. So if you see a little bit of discrepancy in other reported numbers, it's it could be a rounding protocol in play. So set aside rural 20% is about 2,000 or 1,988. The 10% is 994. The 2% is 199. Set aside total about 3,200, 3,192. Here is what happened in the first year of RIA. This is fiscal 2022. We had a large number in the annual EB side of our annual limits, because we had a lot of unused numbers from family sponsored flowing over from COVID consular closures. So we had about 281,507 in the employment-based annual limit. Our 7.1% was almost 20,000. And so the 68% was about 13,590. And the set aside total was double what we would have had in a normal year. And we had 6,394, none of which was used. And so by the carryover mechanism, all the 6,394 numbers were carried over into their same set aside categories in fiscal 2023, which was last fiscal year. And then they were added to the annual allocation of the set asides for that year, which were still larger than the normal year, because we still had numbers coming over from unused family-sponsored sides still in fiscal 2023. So we had about 50,000, a little less, more than we would under the normal limit. And so all of those additional numbers flowed down across the EB-5 categories. And so we had in the set-asides about 11,000 visa numbers, which is triple the normal number that we would have had otherwise. Okay, so now here we are in fiscal 2024. And we still had more numbers than we would normally from the family sponsored fall across. And this is the final number as reported in the September 2024 visa bulletin. There were some adjustments because the State Department got the USCIS data in July of 2024, and making those adjustments resulted in a downward from the estimated 165,000 to the actual 160,791 visas in the EB side of the equation. And so that gave us 11,416, slightly adjusted from my last estimate based on 165,000. And so we have this year in unreserved in fiscal 2024, 14,156 visa numbers. So this is a big number relative to the normal number. Okay, so that's our unreserved number this year. Just really quickly, everyone who registers will get a copy of this PowerPoint, and this will live on YouTube forever. So the set-asides in the rural side, 20%, a little downward adjustment there from my previous number, 2,283. The high unemployment, 1,141. Infrastructure, 228. Total, 3,652 set-asides. And then you add that to the carryovers from last year, we have 8,130 set-asides this year. What we don't know for fiscal 2025 is how many of these set-aside numbers were used or will have been used by September 30, the end of fiscal 2024. What we have are little bursts of information. The last burst of information that we got from the State Department dates to May 2024, when the State Department reported that there were 330, I believe is the number, it could be 334, visas registered waiting at the National Visa Center from the set-asides, the applications associated with set-asides that had been approved. Now, there was a clarification, as our good friend Suzanne Lizicki reported in, that is the number of the principal applicants, so we triple that. So there's been about 900, let's assume there's more than that, right? Because that was what was reported in May. So as of May, about 900 in the NVC queue. That's a small fraction of the 8,130. What we don't know is how many adjustments of status concurrently filed associated with RIA petitions in the set-aside categories are also in queue. And that is going to tell us how many will carry over into the unreserved for fiscal 2025, as well as tell us how many will carry over in the same categories in 2025. We don't know that. We don't have those numbers. This is the State Department estimate of the set-aside total for fiscal 2025, 6,839. So it is over double the normal limit and less than what we had this year in fiscal 2024. And so how that actually pans out is going to depend on the actual usage and the data that we will see that we don't yet have reporting usage as of the end of fiscal 2024. I'm going to skip this so we can get to the questions. I do encourage folks to take a quick look at this on the video and on the PowerPoint slides. These are sort of key concepts that will help you deconstruct and understand the visa bulletin. So these categories, for example, these are the categories that are represented in the unreserved, C5, T5, I5, R5. What do they mean? They mean direct non-TEA for C5s, T5s, direct TEA, so standalones, I-5, which is the dominant category for pre-RIA cases, RC TEA, and R5 RC non-TEA cases. Also popped in here are these codes that are on approval notices of post-RIA 526 approvals. Rural is they're going to have two designations. They're going to have unreserved designations and the relevant set-aside designation. So RU1 is unreserved RC investor, regional center investor. Okay, unreserved regional center investor. Rural regional center investor is going to have the RR1 designation or classification. TEAs are going to have RH1 designation or classification. Standalone approval notices will show NU6 for the unreserved if they're not in a TEA. And for TEAs, they will show a classification of NR6, RR and R6 for rural. We have not had an approval of a standalone high unemployment, but I expect that it would have the classification NH6. Visa bulletins. I encourage everybody to look at the visa bulletin if you're not already assiduously studying it. So the set-asides are here. Everything is current. We have cutoff dates reported in the unreserved right here. We have a cutoff for China mainland-born investors, January 1, 2017, and for Indian investors, April 1, 2022. So they're a couple of years behind Chart A in Chart B. There is more to say. I want to try to absorb and respond to some questions. So there are the developments that are worth highlighting in connection with unreserves. Number one, the State Department reports that the unreserves were on track to use up all of the unreserves in EB-5 this fiscal year. Tremendous. It's fantastic. So remember, it's the 14,000 number, which is great for all of our pre-RIA investors, right? Second thing to note is the recent litigation that has been filed by regional centers and IIUSA, where the regional centers and IIUSA are challenging the USCIS and the State Department in the way that they are evidently interpreting what to do with the unreserved EB-5 visas if they hadn't all been used this fiscal year, or if they're not on track to be all used this fiscal year. What happens if what would have happened if we only used half? So 7,000 were allocated and 7,000 were still hanging out in unreserved at the end of September 30. What would happen? Well, the State Department has said by normal operation of the INA, those numbers would fall up to EB-1, which is how they operated pre-RIA. The argument is that, well, the RIA has changed that pre-RIA mechanism, and Congress intended those numbers, once they carried over to unreserved, to stay there for EB-5 use forever. And this is an argument that we made to the State Department many months ago, and now it is being pressed forward in litigation. So this remains to be seen how this will all play out. This year, we have the great benefit of the unreserves all being used. But what about in subsequent years when that may not be the case? We have a very, very good argument that those numbers should stay within the unreserved for use by the pre-RIA investors who have been waiting for a very long time. Some more vocabulary as a resource. We're always looking for windows into the box to get more information. I mean, where are we? And there are good resources. Take a look at these that are published by the State Department and USCIS. And now, at last, ready for some questions.
Well, I have some questions for you, Carolyn. And
Awesome.
for all those people who tell lawyers that they can go to law school and never have to do math, you have just proved them all wrong.
Well, thank goodness it's fairly simple arithmetic, but it's just the way they weave in and out and cross it. It does get a little complicated.
So with the Department of State announcement that all of the unreserved visas have been reached for the fiscal year, how does that correlate with the September visa bulletin that does still show some of the categories as being current for EB-5, some of the unreserved countries other than mainland China and India?
Yes. So if I understand that question correctly, Lindsay, let's go back to my favorite,
that chart. Yeah.
Dear chart. I just love this. So oops, you're talking about the visa bulletin.
The visa bulletin chart.
Yes.
So all those current fifth reserve, unreserved, all chargeability areas except China mainland and India.
Gotcha. What does that mean?
Showing current, but what does it mean that the unreserves have actually been used up?
Gotcha. Great question. Okay. So I think that the State Department is reporting is that they are on track to use up all of the unreserved this fiscal year. So I do believe they are still chugging along, and USCIS as well. All of those RFEs out there for 693s for medicals. I believe that is an attempt, good faith attempt on USCIS's part to turn out those adjustment of status approvals so that we can use up those numbers. So we still have numbers. And so that explains the numbers, the current designation in the rest of the world.
And so it means that USCIS should still accept adjustment of statuses. And will consulates be issuing visas?
Great question. So they should, yes, yes, across the board and in this way. So if you're a mainland-born China investor and you have a priority date earlier than December 15, 2015, then if you're documentarily qualified and you have you're ready to be interviewed, you are still eligible to be called in to be interviewed. There are numbers available for you. So same thing with Indian investors. If you have a priority date earlier than December 1, 2020, you can be called in for an interview if you're documentarily qualified. Now, I mean, there's logistics as well. So if you're documentarily qualified, but you haven't gotten your packet for interview notice, it is mid-September. It may not happen, it may not line up, but there is visa availability for you. And then if you're an investor from Canada, Nigeria, South Korea, anywhere else in the world, if you're documentarily qualified and logistically, you know, you've been scheduled for an interview. I mean, let's just take that case. You've been scheduled for an interview for September 27th. Can you be issued a visa? Yes. Do not reschedule that interview. Go. Take your kids out of school. Attend the interview. I hope I answered the question.
Yeah, absolutely.
Okay.
Absolutely.
Cool.
And then should this impact people's plans for filing their I-526s?
The unreserved, which part?
Just the what the current predictions are for availability of visas
In 2025?
in 2025. Yeah.
Oh, let's take a look at that, because we get those questions, right? Like, so what do you think? I mean, what should I do? And
Exactly.
what's gonna happen in 2025? So we are told, I mean, this is as of like May, June 2024, that it is looking like the set-asides will remain current throughout 2025. Now, that would be fantastic, right? Because that means it'll be C across the board for, 2025. And so everybody in the set-asides can continue to concurrently file their adjustments of status.
Mhm.
That would be amazing. I am a little bit skeptical because we don't have that window into the actual usage of the set-asides in fiscal 2024. We have that good number, that 330 number of cases registered at the National Visa Center, and we can kind of, do some extrapolation. Okay, so that's 900. We do not have solid adjustment of status concurrently filed numbers for fiscal 2024. And we need those two numbers to figure out how many are going to carry over the next year, which will then determine how many we have. And then even when we have that number, which will be the starting point, we then will need to have a sense of, well, how many cases are ahead in queue? And we don't have great visibility there either, thanks to AIIA, who sued under FOIA and obtained data. We have the data about the cases that are in queue, but only as of November 2023, many months ago. So we don't have great visibility, which is what makes me a little bit more conservative in just expressing my, we don't know. We don't know what it's going to look like in 2025. High degree of confidence that early fiscal 2025, so October, November, December, the first quarter, certainly looks like we're clear for concurrent filings and things remaining current in the set-asides. But beyond that, we're going to have to see what's reported in the actual usage for fiscal 2024.
Wonderful. Thank you.
You're welcome.
I'm not seeing other questions, and it's the allotted time. Should we discuss any other questions?
I would love, okay, so here's, I'm seeing some questions in our
Oh, you are? Okay.
window. So I'm gonna take one, we've got to take one from Suzanne. I mean, you're asking a question, but I bow to you, Suzanne. But I'm going to just humor ourselves and read the question. You might remind everyone who can and will get allocated an unreserved visa, in case people don't realize that all pre-RIA can only get unreserved, while post-RIA, yes, true. All pre-RIA can only get unreserved, while post-RIA are allowed to notify NVC to request unreserved should they so wish. Although we tried to do that, the process is not smooth, let's just say. Assuming that one of the codes listed on the I-526E approval notice, which it usually seems to be, even for set-aside investors, didn't quite understand that part, Suzanne. Do elucidate if you can. I'm not sure I have the technical savvy to open the floor up to attendees. But yes, so one of the points that Suzanne is making to remind us all if you're a pre-RIA investor, you only have the unreserved. For now, under the current interpretation, although there is, I must say, there have been some tries to test that interpretation as well. Do pre-RIA investors, can they get into the set-aside queues? Question, another question. What considerations should govern the selection of visa category by an IB applicant chargeable to China with an approved I-526E who is eligible for both rural and an unreserved visa? So, okay, so Bob is asking about a mainland Chinese investor who's got a priority date earlier than the cutoff date of December 15, 2015. So let's say his investors got December 1, 2015. And so he's current under the unreserved. The answer is, if it's a pre-RIA investor, this was Suzanne's point, you can only choose the unreserved. You should not be given the option, and you won't. NVC will not give pre-RIA the investors the menu of options. You will be given your usual NVC fee bill, and off you go with that process. If that process gets started reasonably, that's another thing, not for this talk today, but tremendous delays from USCIS to the NVC to start that process, which does go to the advocacy about optimizing the use of our precious numbers. We can't do that so well if there's delay between the cases going over to the NVC. Oh, interesting. I'd love to hear more about, okay. Yes, it is very interesting. We're going to not have time to go into it too much today, but I hope we will have the opportunity to, maybe when we talk about cap subject, the per country caps, so this is now kind of mechanics of how all of this is being implemented on the ground by the agencies. So your 526E will be approved, hopefully. Where is that? No, got to go back. Oops, should I go too far back? No, I did. Where do I want to go here? Okay, here we are. So your 526E is approved. Let's just say rural. And so your approval notice is going to have on the right-hand side, it's going to say approval. It's going to have these two codes under it. It'll say, are you 1 or are you 6? Unreserved RC investor, regional center investor, principal, I think it also says, and RR1 or RR6, rural regional center principal investor. When your case is started, and we are observing that for post-RIA investors, that process from USCIS approval to the NVC, very quick. And our understanding is that that process for post-RIA cases is electronic, whereas for pre-RIA investors, it's literally physical file transfer. You can imagine how cumbersome that is. So the NVC, you'll get an email from the National Visa Center that says, please choose. Go into the portal and choose which of the two categories you would like your case associated with. And because the unreserves were current for our clients, sort of being good citizen minded and wanting to reserve the reserve categories for those who really needed it, who had no other slot to go into, we tried to choose unreserved, but couldn't. We were stymied. And the process of communicating through the NVC portal is itself very cumbersome. And so, making the argument, or the point really, the explaining that in this instance, the investor does in fact, as contemplated as being a possibility, qualifies for both categories, just sort of kept getting shown, no, you're wrong. They can't go into unreserved. They're clearly rural, so that's where they've got to go into. And we tried several times, but at some point, the case needs to move on so they can be issued the visa that this fiscal year if possible. So we had to, in that instance, just go with rural and move forward. So the process is cumbersome. It's not, and it's new. So there are some kinks and hinks that do have to be worked out. What other questions are in queue that we can answer?
I think that's it.
That is it. Well, let me stop sharing here if I can. Lindsay, thank you.
Thank you for answering all of our questions.
It is a pleasure, and there are more to come, I'm sure. So stay tuned, and we will be in touch again very soon. Be well, everyone. Talk to you soon.
Bye.